Hi, my name is Akiva Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're continuing our video series designed to educate and inform the public, so please subscribe to our channel. A lot of times people want to know how to file motions. You know, there are court rules, there are local court rules, there are certain ways to do certain things. And because a lot of jurisdictions have different ways that very slightly, they change a little bit from one county to another, from one court to another, it's probably appropriate to have your lawyer, who's an expert at this, determine what motion should be filed. But let's say you're trying to do it on your own. What's the general proposition? Well, first of all, if you are asking, how do I file a motion? I suppose it's appropriate to know what a motion is. A motion is something where you're asking the court to do a certain thing. You're asking the court to grant or deny certain relief or whatever. That's basically what a motion is. It should be in writing. It should follow a certain format where the parties are identified and the case caption and by case number. And then it should, in a short and plain statement of the facts, without a lot of opinion, without a lot of hyperbole, should set forth what the scenario is and what it is that you want the court to do. Now, once you draft that motion and you will file it with the court, there's usually a filing fee that has to be paid. And make sure to make multiple copies of that motion, because you're going to have to serve that motion on the other side. You may have to send a copy of that motion to the friend of the court as well. You'll need a copy for yourself. There may be a specific judge's copy that's required given the rules of that court. So you're going to need at least 4 of these copies. And if there's multiple defendants, you'll need more than that. Once everybody is furnished with a copy, you're going to have to file a proof of service with the court that says, I have filed this motion and I have let everybody know that I'm filing this motion. Another thing you're going to have to do is you're going to have a notice of hearing. Now, in order for the court to grant you relief, to at least hear you out, you have to have a hearing. You have to come before the court and say what you want. The other side gets to oppose it if they so desire, and the court makes a ruling. But that has to be on a certain day. And that means you're going to have to find out when that notice of hearing when that hearing should be heard. And that date, a time, would have to be filled out in that notice of hearing. How do you get that date and time? Well, normally what you would do is, and what we do here in the office is, we could just pick a random date and time, but picking a random date and time does not guarantee that the court's available to hear you on that day. So a good practice is to file a motion, precipice, and a notice of hearing, which gives a date and time that you gotten from the court clerk. So what is involved there is you have to find out who the judge is, and you got to call that judge's clerk and say, look, I have a motion I want to bring before the court. I want to, for example, ask for more parenting time. When would be the first available time that I can schedule that motion? They'll say, okay, you can do it next Wednesday, 9 a.m. So you notice it up. For the next Wednesday, 9 a.m., you'd send a notice of hearing to the court, you'd send a notice of hearing to the clerk, you'd send one to the opposing side, make sure everybody knows, you put it in your own book, you'd file the notice of hearing, and you file a proof of service that everybody got one. And I'll tell you why. Because if you come to that date and time, and the court has you in the calendar, and you are ready to go forward with your motion, and the other seat is empty, the court's going to say, wait a minute, where's the other side? I don't know, Judge. I don't know where they are. And the court's then going to ask you, well, wait a minute. Did you send them a notice of hearing? Did you tell them to be here on this day? And if you say yes, the court's going to say, let me see your proof of service. So you're going to have to file a proof of service that says, I put in the mail by certified mail or however you're going to do it in accordance with the court rules that you've done that. And if you can prove it, the court has the option of going forward without them. And having the hearing without them. The court can adjourn, the court can do all sorts of things, but those are things that you're going to have to do to get to schedule before the court. If you have any questions about that, reach out and we'll be glad to help you out.